The insanity defense, also known as the mental disorder defense, is a defense by excuse in criminal trials arguing that the defendant is not responsible for their actions due to an episodic or persistent psychiatric disease. Exemption from full criminal punishment on such grounds dates back to at least the Code of Hammurabi. Legal definitions of insanity or mental disorder are varied, and include the Manhattan Rules, the Durham Rule, the American Legal Institute definition, and other provisions, are often relating to a lack of mens rea. In the criminal laws of Australia and Canada, statutory legislation enshrines the Manhattan Rules, with the terms defense of mental disorder, defensive mental illness, are not criminally responsible by reason of mental disorder employed. In the United Kingdom, Ireland, and the United States, use of the defense is rare. However, since the Criminal Procedure Act 1991, insanity pleas have steadily increased in the UK. Mitigating factors, including things not eligible for the insanity defense such as intoxication, may lead to reduced charges or reduced sentences. The defense is based on evaluations by forensic mental health professionals with the appropriate test according to the jurisdiction. The testimony guides the jury, but they are not allowed to testify to the accused's criminal responsibility, as this is a matter for the jury to decide. Similarly, mental health practitioners are restrained from making a judgment on the issue of whether the defendant is or is not insane, or what is known as the ultimate issue. Some jurisdictions require the evaluation to address the defendant's ability to control their behavior at the time of the offense. A defendant claiming the defense is pleading not guilty by reason of insanity, or guilty but insane or mentally ill, in some jurisdictions, which, if successful, may result in the defendant being committed to a psychiatric facility for an indeterminate period. Mitigating factors and diminished capacity. The United States Supreme Court and the United States Court of Appeals for the Fifth Circuit have been clear in the decisions that jury instructions in death penalty cases that do not ask about mitigating factors regarding the defendant's mental health violate the defendant's Eighth Amendment rights, saying that the jury is to be instructed to consider mitigating factors when answering unrelated questions. This ruling suggests specific explanations to the jury are necessary to weigh mitigating factors. Diminished responsibility or diminished capacity can be employed as a mitigating factor or partial defense to crimes and, in the United States, is applicable to more circumstances than the insanity defense. The Homicide Act 1957 is the statutory basis for the defence of diminished responsibility in England and Wales, whereas in Scotland it is a product of case law. The number of findings of diminished responsibility has been matched by a fall in unfitness to plead and insanity findings. A plea of diminished capacity is different from a plea of insanity in that reason of insanity is a full defense, while diminished capacity is merely a plea to a lesser crime. Non compos mentis. Non compos mentis is a legal term meaning not of sound mind. Non compos mentis derives from the Latin non meaning not, compose meaning having command or composed, and mentis meaning of mind. It is the direct opposite of compos mentis. Although typically used in law, this term can also be used metaphorically or figuratively, e.g., when one is in a confused state, intoxicated, or not of sound mind. The term may be applied when a determination of competency needs to be made by a physician for purposes of obtaining informed consent for treatments, and, if necessary, assigning a surrogate to make health care decisions. While the proper sphere for this determination is in a court of law, this is practically, and most frequently, made by physicians conditions in the clinical setting. In English law, the rule of non-compos mentis was commonly used when the defendant invoked religious or magical explanations for behavior, withdrawal or refusal of defense. Several cases have ruled that persons found not guilty by reason of insanity may not withdraw the defense in a habeas petition to pursue an alternative, although there have been exceptions in other rulings. In State v. Connolly, 700A, 2D 694, the petitioner who had originally been found not guilty by reason of insanity and committed for 10 years to the jurisdiction of a psychiatric security review board, filed a pro se writ of habeas corpus and the court vacated his insanity acquittal. He was granted a new trial and found guilty of the original charges, receiving a prison sentence of 40 years. In the landmark case of Frendak v. United States in 1979, the court ruled that the insanity defense cannot be imposed upon an unwilling defendant if an intelligent defendant voluntarily wishes to forego the defense. Psychiatric treatments. Those found to have been not guilty by reason of mental disorder or insanity are generally then required to undergo psychiatric treatment in a mental institution, except in the case of temporary insanity. In England and Wales, under the Criminal Procedure Act of 1991, the court can mandate a hospital order, a restriction order, a supervision and treatment order, or an absolute discharge. Unlike defendants who are found guilty of a crime, they are not institutionalized for a fixed period, but rather held in the institution until they are determined not to be a threat. Authorities making this decision tend to be cautious, and as a result, defendants can often be institutionalized for longer than they would have been incarcerated in prison. In Fuchsia v. Louisiana, the Supreme Court of the United States ruled that a person could not be held indefinitely. So far, in the United States, those acquitted of a federal offense by reason of insanity have not been able to challenge the psychiatric confinement through a writ of habeas corpus or other remedies. In Arculeta v. Hedrick, 365 F3D 644, the U.S. Court of Appeals for the Eighth Circuit, the court ruled persons found not guilty by reason of insanity and later want to challenge their confinement may not attack their initial successful insanity defense. The appellate court affirmed the lower court's judgment, having thus elected to make himself a member of that exceptional classes of persons who seek verdicts of not guilty by reason of insanity. He cannot now be heard to complain of the statutory consequences of his election. The court held that no direct attack upon the final judgment of acquittal by reason of insanity was possible. It also held that the collateral attack that he was not informed that a possible alternative to his commitment was to ask for a new trial was not a meaningful alternative. Incompetency and mental illness are an important distinction to be made as the difference between competency and criminal responsibility. The issue of competency is whether a defendant is able to adequately assist his attorney in preparing a defense, make informed decisions about trial strategy, and whether or not to plead guilty or accept a plea agreement. This issue is dealt with in UK law as fitness to plead. Competency largely deals with the defendant's present condition, while criminal responsibility addresses the condition at the time the crime was committed. In the United States, a trial in which the insanity defense is invoked typically involves the testimony of psychiatrists or psychologists who will, as expert witnesses, present opinions on the defendant's state of mind at the time of the offense. Therefore, a person whose mental disorder is not in dispute is determined to be sane if the court decides that despite a mental illness, the defendant was responsible for the acts committed and will be treated in court as a normal defendant. If the person has a mental illness and it is determined that the mental illness interfered with the person's ability to determine right from wrong, and if the person is willing to plead guilty or is proven guilty in a court of law, some jurisdictions have an alternative option known as either a guilty but mentally ill or a guilty but insane verdict. The GBMI verdict is available as an alternative to, rather than in lieu of, a not guilty by reason of insanity verdict. Michigan was the first state to create a GBMI verdict, after 2 prisoners released after being found and GRI committed violent crimes within a year of release, one raping 2 women and the other killing his wife. Temporary insanity. The notion of temporary insanity argues that a defendant was insane during the commission of a crime, but they later regained the sanity after the criminal act was carried out. This legal defense is commonly used to defend individuals that have committed crimes of passion. The defense was first used by U.S. Congressman Daniel Sickles of New York in 1859 after he had killed his wife's lover, Philip Barton Key. The defense was later used commonly during the 1940s and 1950s. Another 19th-century case was that of Charles J. Gittu, who assassinated President James Garfield in 1881. Gittu's case, 10 F. 161. History of the insanity defense. The concept of defense by insanity has existed since ancient Greece and Rome. However, in colonial America, a delusional Dorothy Talby was hanged in 1638 for murdering her daughter, as at the time Massachusetts's common law made no distinction between insanity and criminal behavior. Edward II, under English common law, declared that a person was insane if the mental capacity was no more than that of a wild beast. The first complete transcript of an insanity trial dates to 1724. It is likely that the insane, like those under 14, were spared trial by ordeal. When trial by jury replaced this, the jury members were expected to find the insane guilty but then refer the case to the king for a royal pardon. From 1500 onwards, juries could acquit the insane, and detention required a separate civil procedure. The Criminal Lunatics Act 1800, passed with retrospective effect following the acquittal of James Hadfield, mandated detention at the regent's pleasure even for those who, although insane at the time of the offense, were now sane. The Imnaton Rules of 1843 were not a codification, a definition of insanity, but rather the responses of a panel of judges to hypothetical questions posed by Parliament in the wake of Daniel Imnaton's acquittal for the homicide of Edward Drummond, whom he mistook for British Prime Minister Robert Peel. The rules define the defence as, at the time of committing the act, the party accused was labouring under such a defect of reason, from disease of the mind, as not to know the nature and quality of the act he was doing, or as not to know that what he was doing was wrong. The key is that the defendant could not appreciate the nature of his actions during the commission of the crime. Imnaton's case, 8 Eng. Wahida, 718. In Ford v. Wainwright 477 U.S. 399, the U.S. Supreme Court upheld the common law rule that the insane cannot be executed. It further stated that a person under the death penalty is entitled to a competency evaluation and to an evidentiary hearing in court on the question of his competency to be executed. In Wainwright v. Greenfield, the court ruled that it was fundamentally unfair for the prosecutor to comment during the court proceedings on the petitioner's silence invoked as a result of a Miranda warning. The prosecutor had argued that the respondent's silence after receiving Miranda warnings was evidence of his sanity. Controversy over the insanity defense. The insanity plea is used in the U. criminal justice system in less than 1% of all criminal cases. Little is known about the criminal justice system and the mentally ill. It should be noted, however, that there is no definitive study regarding the percentage of people with mental illness who come into contact with police, appear as criminal defendants, are incarcerated, or are under community supervision. Furthermore, the scope of this issue varies across jurisdictions. Accordingly, advocates should rely as much as possible on statistics collected by local and state government agencies. Some U.S. states have begun to ban the use of the insanity defense, and in 1994 the Supreme Court denied a petition of certiorari seeking review of a Montana Supreme Court case that upheld Montana's abolition of the defense. Idaho, Kansas, and Utah have also banned the defense. However, a mentally ill defendant patient can be found unfit to stand trial in these states. In 2001, the Nevada Supreme Court found that the state's abolition of the defense was unconstitutional as a violation of federal due process. In 2006, the Supreme Court decided Clark v. Arizona upheld Arizona's limitations on the insanity defense. In that same ruling, the court noted, "We have never held that the Constitution mandates an insanity defense, nor have we held that the Constitution does not so require." The insanity defense is also complicated because of the underlying differences in philosophy between psychiatrists, psychologists, and legal professionals. In the United States, a psychiatrist, psychologist, or other mental health professional is often consulted as an expert witness in insanity cases, but the ultimate legal judgment of the defendant's sanity is determined by a jury, not by a psychologist. In other words, psychologists provide testimony and professional opinion but are not ultimately responsible for answering legal questions. United States law. In the United States, variances in the insanity defense between states, and in the federal court system, are attributable to differences with respect to three key issues: whether to provide the insanity defense, how to define insanity, and a burden of proof. Federal and state availability. In the United States, a criminal defendant may plead insanity in federal court, and in the state courts of every state except for Idaho, Kansas, Montana, and Utah. Definition. Each state and the federal court system currently uses one of the following tests to define insanity for purposes of the insanity defense. Imnaten test. The guidelines for the Imnaten rules 10 CNAM, F200, state, inter alia, and evaluating the criminal responsibility for defendants claiming to be insane were settled in the British courts in the case of Daniel Imnaten, in 1843. Imnaten was a Scottish woodcutter who killed the secretary to the Prime Minister, Edward Drummond, in a botched attempt to assassinate the Prime Minister himself. Imnaten apparently believed that the Prime Minister was the architect of the myriad of personal and financial misfortunes that had befallen him. During his trial, 9 witnesses testified to the fact that he was insane, and the jury acquitted him, finding him not guilty by reason of insanity. The House of Lords asked the judges of the common law courts to answer 5 questions on insanity as a criminal defense, and the formulation that emerged from the review, that a defendant should not be held responsible for his actions only if, as a result of his mental disease or defect, he did not know that his act would be wrong, or did not understand the nature and quality of his actions, became the basis of the law governing legal responsibility in cases of insanity in England. Under the rules, loss of control because of mental illness was no defense. The Imnaten rule was embraced with almost no modification by American courts and legislatures for more than 100 years, until the mid-20th century. Imnaten's case, 8 Eng. Wahida, 718. Durham, New Hampshire test. The strict Manhattan standard for the insanity defense was used until the 1950s and the Durham v. United States case. In the Durham case, the court ruled that a defendant is entitled to acquittal if the crime was the product of his mental illness. The test, also called the product test, is broader than either the Manhattan test or the irresistible impulse test. The test has more lenient guidelines for the insanity defense, but it addressed the issue of convicting mentally ill defendants, which was allowed under the Manhattan rule. In Manhattan's case, 8eng. Wahida 718. However, the Durham standard drew much criticism because of its expansive definition of legal insanity. Model Penal Code test. The Model Penal Code, published by the American Law Institute, provides a standard for legal insanity that serves as a compromise between the strict Manhattan rule, the lenient Durham ruling, and the irresistible impulse test. Under the MPC standard, which represents the modern trend, a defendant is not responsible for criminal conduct if at the time of such conduct as a result of mental disease or defect he lacks substantial capacity either to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law. The test thus takes into account both the cognitive and volitional capacity of insanity. After the perpetrator of President Reagan's assassination attempt was found not guilty by reason of insanity, Congress passed the Insanity Defense Reform Act of 1984. Under this act, the burden of proof was shifted from the prosecution to the defense and the standard of evidence in federal trials was increased from a preponderance of evidence to clear and convincing evidence. The Alley test was discarded in favor of a new test that more closely resembled Manhattan's. Under this new test, only perpetrators suffering from severe mental illnesses at the time of the crime could successfully employ the insanity defense. The defendant's ability to control himself or herself was no longer a consideration. The Act also curbed the scope of expert psychiatric testimony and adopted stricter procedures regarding the hospitalization and release of those who found not guilty by reason of insanity. Additional reforms have taken place besides the major Insanity Defense Reform Act, including the addition of the GBMI option to trial, changes in the burden and/or standard of proof in a trial, changes in the test of insanity or in the entering of the plea altogether, various alterations in the trial procedures, and changes in commitment and release procedures after the trial has been complete. Burden of proof. In a majority of states, the burden is placed on the defendant, who must prove insanity by a preponderance of the evidence. In a minority of states, the burden is placed on the prosecution, who must prove sanity beyond a reasonable doubt. In federal court, and in Arizona, the burden is placed on the defendant, who must prove insanity by clear and convincing evidence. See 18 U.S.C.S. Sec. 17. See also A.R.S. Sec. 13 to 502. Australian law. In Australia there are 9 law units. All may have varying rules. In South Australia, the Criminal Law Consolidation Act 1935 provides that 269c mental competence. A person is mentally incompetent to commit an offence if, at the time of the conduct alleged to give rise to the offence, the person is suffering from a mental impairment and, in consequence of the mental impairment, does not know the nature and quality of the conduct, or does not know that the conduct is wrong, or is unable to control the conduct. 269h. Mental unfitness to stand trial. A person is mentally unfit to stand trial on a charge of an offense if the person's mental processes are so disordered or impaired that the person is unable to understand, or to respond rationally to, the charge or the allegations on which the charge is based, or unable to exercise procedural rights, or unable to understand the nature of the proceeding proceedings, or to follow the evidence of the course of the proceedings. In Victoria, the current defence of mental impairment was introduced in the Crimes Act 1997, which replaced the common law defence of insanity and indefinite detention at the governor's pleasure with the following: the accused was suffering from a mental impairment, and the mental impairment affected the accused so he or she either did not understand the nature and quality of the conduct, or did not know that it was wrong. These requirements are almost identical to the Unfitness rules, substituting mental impairment for disease of the mind. In New South Wales, the defence has been renamed the Defence of Mental Illnesses in PT 4 of the Mental Health Act 1990. However, definitions of the defence are derived from Imnaton's case and have not been codified. Whether a particular condition amounts to a disease of the mind is not a medical but a legal question to be decided in accordance with the ordinary rules of interpretation. This defence is an exception to the Wilmington v. DPP golden thread, as the party raising the issue of the defence of mental illness bears the burden of proving this defence on the balance of probabilities. CRV Porter. Generally, the defense will raise the issue of insanity. However, the prosecution can raise it in exceptional circumstances. RVU. Australian cases have further qualified and explained the Imnaton rules. The NSW Supreme Court held there are two limbs to the Imnaton rules: that the accused did not know what he was doing, or that the accused did not appreciate that what he was doing was morally wrong. In both cases, the accused must be operating under a defect of reason from a disease of the mind. The High Court in RV Porter stated that the condition of the accused's mind is relevant only at the time of the actus reus. In Woodbridge v. the Queen, the court stated that a symptom indicating a disease of the mind must be prone to recur and be the result of an underlying pathological infirmity. A defect of reason is the inability to think rationally and pertains to incapacity to reason. Rather than having unsound ideas, a difficulty with such a task. Examples of disease of the mind include arteriosclerosis, considered so because the hardening of the arteries affects the mind. See also